Yes, welcome. Please go ahead.
Thank you. Chair Goodman and members of the committee, I'd like to thank you for the opportunity to testify today. My name is John Nowels. I am the Sheriff of Spokane County and the current president of the Washington Association of Sheriffs and Chiefs of Police. I would also let you know that I have now held my Washington State Peace Officer certification for 28 years, and I don't foresee myself doing anything in the future that would jeopardize that. However, I am testifying in opposition of Substitute Senate Bill 5974. This legislation undermines two bedrock principles of Washington state law: voter sovereignty and free elections. First, this bill allows the Criminal Justice Training Commission decertification to vacate an elected sheriff's office, bypassing the constitutional recall process reserved to voters under Article 1, Sections 33 and 34 of the state constitution. Removal of an elected official must remain in the hands of the people, not an unelected board. Second, pre-filing CJTC approval creates an unelected gatekeeper to candidacy, violating Articles 1 and Section 19, guarantee of free and equal elections. These provisions disenfranchise voters and chill competition. Beyond constitutional defects, these bills impose unfunded mandates, costly background checks, policy rewrites, and volunteer restrictions that cripple search and rescue and chaplaincy programs. Spokane County estimates over $100,000 in compliance and litigation exposure if this legislation passes. Current law and the Washington State Constitution prescribe appropriate remedies for elected sheriffs who violate the law or their oaths of office, in addition to requiring any elected sheriff to obtain and maintain peace officer certification. I urge you to reject this legislation and halt this transgression on voter rights and the state constitution. As constituted, this legislation does not accomplish any of the goals stated in its preamble, and legislators must reject the legislation or adopt amendments removing decertification-based vacancy, striking pre-filing approvals, and narrowing volunteer limits. Additionally, the people who have testified in front of you today have brought up issues that they see with people holding and conducting the office of sheriff. There are already constitutionally prescribed remedies for this. It is meant to be a high bar to remove an elected official from office. We should not leave this in the hands of an unelected board of people who do not have necessary experience to determine whether a sheriff has acted inappropriately or not. That is something that is reserved for the voters who place them in office, and it is the same process that is used for every elected official in the state of Washington. Thank you.
Thank you very much. Thanks to both of the sheriffs. I have actually a Sheriff Garcia, if you could come up, and we'll have you testify just a moment. Either for both of you, Sheriff Carter, Sheriff Nowels, the sheriff, the Superior Court judge, and the county prosecutor office are all constitutional. They're all established in the Constitution. And if a Superior Court judge or county prosecutor is disbarred, the statute provides that an immediate vacancy is created. There is no recall for those constitutionally created offices. And so I'm wondering where the vacancy statute and other triggers as well. So for instance, county commission or city council members, if they miss 3 meetings in a row, by statute they are automatically booted out. They're not subject to a recall. So why is it that the sheriff would be subject to voter sanction or voter response when the license is taken away, when a Superior Court judge or a county prosecutor must leave office immediately if their license is taken away? What's the distinction?
So I can speak to that. My understanding is that every member of the bar has to be admitted to the bar, and if they do go through a process where their bar license is removed, they do have the option, and I believe the right, to go in front of the Washington State Supreme Court, who are elected officials, to appeal their case. And I believe it's once they get to that point where there are elected officials, the Washington State Supreme Court, that actually make that determination that would cause them to be removed from office.
I think that, oh, by the way, also, the CJTC is taken out of the bill in the striking amendment. You haven't seen that yet, so just wanted to make sure we address that concern, so.
Okay.